Dr. D. Rajasekar, Professor, Amet Business School, Amet University, and today's lecture, Introduction to Maritime Law. The Maritime Law, which is also called as Admiralty Law or Shipping Law. In the recent days, this maritime law which is most important, but for maritime law means there are other important laws also which may come into force, which we are going to discuss with some important features which is going to connect with the proper explanation of what is the meaning for maritime law. So, first one is the maritime law which connects, first one is maritime commerce, and the second one is navigation, third one is called as Carriage of Goods by Sea Act. Now, here maritime commerce means called as trade. Commerce means trade, for the goods need to be taken from one place to another place. There are various modes of transportation is there, rail transport is there, road transport is there, air transport is there, but pertaining to other transport, other mode of transport, the most important mode of transport with the lowest cost, where the people can able to deliver their goods or else they can transport the goods from one place to another place, called as maritime trade related to shipping. Now, this trade, there is one act called as Multimodal Transportation Act 1993. As such, I told the shipping law which is not related with only one mode. The multimodal transportation means there are various modes of transportation which connects in taking the goods from one place to another place. For that, they have enacted one act is called as Multimodal Transportation Act 1993. Second one is this maritime which connects navigation, and third one is Carriage of Goods by Sea Act 1925. Now, carriage means that taking the goods from one place to another place, also called as carrier. There are two types of carrier, one is private carrier, another one is common carrier. But now, here the second one is goods, where they are going to take the goods which represent as per shipping term cargo, which they are going to take the one place to goods to be taken from one place to another place by using sea transport. Now, for this sea transport, if any vessel where they are going to take the goods from X to Y, if anything is happened during the time of transportation from one place to another place, which act may come into force means Carriage of Goods by Sea Act 1925, which may come into force. But this maritime law which is deal or governing with three things, one is contract, another one is tort, and third one is workers compensation. Now, what is the meaning for contract? The contract means as per this maritime law, the few people are engaging into the contract. For example, ship owner, charterer, port agents, salvage people. So, each and every person where they are going to enter with the contract with the various agreements. Now, the contract is called as offer. As per the basic formula for contract is offer plus acceptance. It should be enforceable by law. So, offer plus acceptance equal to agreement, and that agreement should be enforceable by law. For example, where the ship owner, charterer enters into an agreement, but the vessel is going to be used for any smuggling purpose, this agreement cannot be accepted as a valid agreement. The agreement can be called as invalid agreement only. So, for that purpose, there one party want to give his ship to the other party, the charterer want to obtain the vessel from the ship owner. They may have the party want to give his vessel is called as offeror, other person need to accept called as accept or acceptance, where both the parties are immediately they need to enter with an agreement for what purpose they are going to enter with an contract. For example, there are various types of charter parties are there. The charterer means the person who is going to hire the vessel is called as charterer. The person who is going to hire the vessel from the ship owner is called as charterer. There are various types. For example, voyage charter party is there, time charter party is there, bareboat charter party is there. So, what type of charter party, who will be liable, when they will be liable, for all these type of things they need to be mentioned in the agreement with the, for that which one is most important. If any one of the party or no not yet follow the rules and regulations, in that cases which act may come into force means Indian Contract Act. This Indian Contract Act which here means 1872. And the second one is tort. The meaning of tort is called as civil wrong. There are various remedies even in the tort. Tort means there is no contract legally binding between the parties. The contract which is not at all required, even the negligence, if anything happened to any party like damaging the goods, damage of goods or loss, but it at its own in, without negligence or with the negligence, but at any cost the party may be liable. During that time he may not say that I have not yet entered into the contract, I may not become under liable. Tort means where the parties may come under liable for the damages or contributory negligence also which will be present. Contributory negligence means where both the parties negligently, if anything, if it has been happened, but here also both the parties are totally liable, which we are going to discuss with a few examples with the few case laws also. So, here the contract, the first one, second one is tort, and third one is workers liable, workers compensation also claim, where any workers where they may not be able to get the claim. For example, the captain of the vessel, if the company want to fail to make the payment to a captain, even in such cases also the person need to be punishable, the company need to be punishable, under which act means under maritime law only. So, for that three important points which you have discussed, the first one is contract legally binding, second one is tort need not legally binding, and third one is workers claims. All these three, but only these three, not like that. There are various types of act, each and every act which is related once the goods it has been loaded in the vessel till they are going to discharge the vessel, there will be a connectivity which is presented in this maritime law, which we are going to discuss with the various types of laws. The first important act is called as Merchant Shipping Act. The Merchant Shipping Act enacted in the year 1958, but this Merchant Shipping Act which may be differ from each and every country, but the Merchant Shipping Act or the Indian shipping where we are going to deal with some technical matters, but for that the common law, India is a common law with the help of international conventions or the international agreements or the agreements between the countries or agreements between the states These are called as international conventions. But what for the international conventions which they have been included in the maritime law? The first one is safety, pollution. Second one is limitation of liability. What type of liability which will be presented here as per the Limitation of Liability Act? And the third one is the prevention of collision. The meaning of collision is where the two ships are going to collision each other is called as collision. But the next one is load line convention, and the last one is International Labour Organization conventions. All these are which is most important, which need to be present in the maritime law commonly for our country, where we have already entered an agreement with the other countries called as international conventions. Now, what are the various laws which will be applicable to maritime law? The first one is, as we have discussed, Merchant Shipping Act 1958. So, not only this act, along with this act another act which may be present. For that, the second one is already which we have discussed, COGSA. COGSA is called as Carriage of Goods by Sea Act, where the carriage of goods by sea, by air, by rail, there are various modes of transportation, but in particular if any goods, if they are going to use by the mode of sea transportation, immediately which act may come into force means Carriage of Goods by Sea Act 1925, which may come into force. And not only that, if any party want to take the goods from the vessel, for that the another important document, there are various types of documents are there, but the most important document related to the maritime law is Bill of Lading. So, next one is Indian Bill of Lading, BOL in short form. Indian Bill of Lading Act is 1856. So, these three acts which is most important. And not only that, the another act also which is most important, as per the international conventions where the two ships are going to collision each other, immediately which act may come into force means marine insurance. The marine insurance also, which is one of the provision which will be applicable under the maritime law. So, Marine Insurance Act which I have presented here, the Marine Insurance Act, Marine Insurance Act 1963. So, first one is the mode of transportation, regarding the Merchant Shipping Act. Second one is goods. Third one is the document Bill of Lading, and the fourth one, if the ship met with an accident, to get the amount of loss or to somewhat to adjust the amount of loss, the one party need to taken the insured with the company. In such cases, which law may come into force means Marine Insurance Act. Marine insurance, it is a contract between the insurer as well as the insured person. Okay. So, indemnity to save the person from the loss, this Marine Insurance Act which is most important, which we are going to dealing with the various types of policies. Even in the Marine Insurance Act, voyage policy is there, time policy is there, value policy is there, unvalue policy is there. Voyage policy means, for example, goods is going to be take the one place to another place. Within that the same route, they have to take the goods from one place to another place. Any routes, any deviation in the routes, in such cases the policy amount which will not be paid, called as voyage. Time means sometimes the ship can be owned by the charterer for the 6 months time, but at the same time during this 6 months period of time policy, where more than 6 months the policy which will be invalid. So, for that during the time alone they can utilize the policy. Value policy means both the parties mutually agreed if there is any damage or loss, called as value policy. If there is no such agreement between the parties not related with the damage or loss, whatever the amount which they are going to suffer, they need to make the payment. In such cases, then it can be called as unvalued policy. So, there are the various types of policies as such which you have discussed, and not only that, there are two major types of insurance are there. The one is hull insurance, where you are going to insure your vessel including the equipments, the machinery is called as hull insurance. If you are going to insure your cargo, is called as cargo insurance. and the ship which was met with an accident, suddenly these type of policies as well as what type of insurance, each and everything which we need to take into consideration to value the amount, how much amount which will be paid to the insured person. For that, which act is most important, means Marine Insurance Act 1963. And these are the acts which is related to the shipping, and the other few important acts are there which is regarding the CRPC, criminals. For example, there are CRPC Act, Criminal Procedure Code is there 1973, next one is Indian Evidence Act is there 1872, next one is Indian Penal Code is there 1860. So, these three which may come under what type of prosecution or proceedings, means criminal prosecution or proceedings. A person need to be punished under criminal prosecution or proceedings, means in such cases they may be value with these three types of important acts which will be included in the maritime law. If they want to initiate legal action, need to be taken against any other person with criminal proceedings. Now, what about the civil? Yes, again the Civil Procedure Code, Civil CPC, Civil Procedure Code is there, and 1908, and Contract Act which you have discussed already 1872, and last one is Company Law Act 2013. So, these three act. For the Companies Act, if any person who want to register the ship, register the company, they need to go with Companies Act 2013. How, what basis they have to incorporate the company, how to register the company, and where they are going to, if they are going to take the place of registration office from one place to another place, there are more number of formalities including the memorandum, articles of association as well as the types of directors, each and everything which in detail which may be presented in the Companies Act 2013. So, like that each and every act which is most important in the maritime law. Now, the next most important point as per the maritime law which we are going to discuss, admiralty, but with this admiralty called as jurisdiction. The another important point, admiralty jurisdiction means it is a called territorial water jurisdiction. Previously, if any party without getting permission, if any vessel wants to enter into any other country, they need to get the proper authorization, then only they can able to enter into that country, but without authorization, if they are going to enter, then that country may have the right to arrest the vessel. And not only that, any loss or damage or including the arrest, they can, if the jurisdiction, if they are going to cross the border of territorial waters jurisdiction, the country may have the right to arrest the vessel. If they are going to arrest the vessel, for which court where they need to go. But now here I have presented for the admiralty jurisdiction. High courts, Mumbai and Madras High Court is there, Kolkata Court is there regarding with the maritime matters. Not only these type of high courts, nowadays they have expanded regarding with within that territorial. For example, if any vessel within the Tamil Nadu, if they are other countries vessel, if they are going to enter into a state of Tamil Nadu without any authorization, then the Tamil Nadu territorial jurisdiction, the court, the Madras High Court, which may have the power to pass the order in arrest the vessel. So, like that each and every states may have the powers where high courts are there, means they may have the powers to arrest the vessel in passing the orders. So, for that territorial water jurisdiction which is most important, also called as admiralty jurisdictions, which I have given one example also. So, here for regarding this admiralty jurisdiction, I have given one example. The Madras High Court is empowered to arrest a vessel found in the waters of Tamil Nadu only. So, with this example very easily you can come to conclude that in each and every states wherever the high courts are there, they may have the right to arrest the vessel which is going to coming under the territorial waters jurisdiction of that particular state. Now, the previous slide which you have discussed about arrest the vessel, but how to arrest the vessel? Is there any provisions to arrest the vessel like arresting a man? Yes, as per the maritime law, we can arrest the vessel, but for that the proper few conventions are there. As such, I have given here the arrest convention 1952, Arrest Convention 1999, which shows that the vessel can be arrested. But India is not a signatory to any of these conventions, but what which has been happened later, which we are going to discuss now. Apart from these conventions, other few more conventions are there where India is empowered to arrest the vessel. The basic important case law for the maritime law is MV Elizabeth versus R1 Investment and Trading Private Limited. India is a common law country. As such, I told the international conventions where we have agreed or had an agreement with any other countries, the laws related to the conventions which will be common. So, our country which is a common law country, conventions of arrest of sea-going ships also, which they have been included in the Brussels Conventions 10th May 1952. After these conventions, even India had enforced the claims of maritime law against the foreign ships. Now, the next another important conventions, as in the principles of 1999 Geneva Arrest Conventions, the Supreme Court passed the order where the Geneva Conventions 1999 also, which will be applicable for arresting a ship in India. So, like that 52, 59 Brussels Conventions at the end, which we have empowered to arrest the vessel, any foreign vessels, if they are going to enter into our country without any proper authorization, our country is having right to arrest the vessel. The same incident which has been happened even in the 12th October in the year of 2013, the incident has been happened where our country which they have been arrest the US vessel also, where they may have some harms without proper authorization or permission, they have entered into our country. So, for that arrest the vessel, when they may have the right to arrest the vessel, on what conditions they may have the right to arrest the vessels, which I have given here. Any damage done by a ship or loss of goods in transit. Transit means during the carrier, if any loss which is happened to the vessel. Salvage means, what is the meaning of salvage? Salvage agreements means to protect or rescue a person or the goods from the vessel, or rescue the person or cargo from the vessel is called as salvage agreements. These salvage agreements also, there is one form called as Lloyd's open form, in short form LOF, Lloyd's open form, the salvage agreements which will be present, but for that any of the party who are not yet satisfied, at the end for these or these for the purpose of salvage agreements, through the Lloyd's open form they can go and approach arbitrator. Arbitrator is a person, one who been appointed to settle the disputes between the parties instead of going to the court. Mutually the problem which will be solved. Arbitrator, also called as arbitration agreements, which will be also present instead of the salvage agreements. And the next one is master's wages. As such, I told, if the company one who failed to provide the wages or the claim or the compensation to any of the employee who have been working in the vessel, even for that the vessel can be arrested. And the disbursements and bottomry. Bottomry means it is an agreement where I am going to given my vessel as per the bottomry agreement for the number of years, but at the same time if I fail to take also, they may have the right to what? Arrest the vessel. So, or else any change in the ownership of the vessel, where as per the agreement, if any one of the party who have not yet follow the rules and the regulations of the agreement, for that which I have told already, which act is most important, means contract act is most important. Always agreement will be there, maybe the ship owner or the charterer or the cargo owner or the port agency or the any other person, those who are related with doing the transaction of needs to take the goods from one place to another place. Each and every transactions they may enter with an agreement, but any person who will not yet follow those agreement, immediately which contract which may come into force, which act which may come into force means Indian Contract Act 1872, but as such each and every transactions related to the shipping, that is the reason which we are discussing here, even the maritime law under the Indian Contract Act, which is important. Now, the contract between whom, what is the meaning of contract? There are various types of contract. Valid contract means where both the parties mutually agreed in doing the business or taking the goods can be called as valid contract. But another one is there called as voidable contract, where forcing or threatening or coercion, then it can be called as voidable contract, where there is no other way by threatening the other person where he is going to involved in doing the transaction with you is called as voidable contract. But unfortunately, the voidable contract in the basic stage may be valid, but later it can be void if the person who is not yet satisfied, or if he is going to oppose where you have forced him to enter into the transaction. The third one is the void contract. For void contract means, yes, both the parties are entered into the contract in doing the business, in hiring the vessel, but for what purpose means only for smuggling purpose. As such, I told the formula for the contract: offer will be there, acceptance will be there, agreement will be there, but it should be enforceable by law. But doing any smuggling business, offer is there, acceptance is there, agreement is there, but what type of agreement means illegal agreement, it should not be enforceable by law. So, for that the contract, what type of people may enter into the contract? Ship owner or the bill of lading document related, charter parties. As such, I told the various types of charter party: voyage charter party, time charter party, bareboat charter party, and the next one is salvage agreements, where the salvage agreements means the person who want to rescue the vessel from the sea. Salvage agreements, as well as the marine insurance company as well as the insured person may have an agreement with the various types of insurance policies, where the time policy, voyage policy, value policy, and unvalued policy. So, these parties, once they have entered, for the various reasons, if there is any dispute between the parties, if it is happened, now which act may come into force means only the contract. Now, what is the meaning of collision? Already which we have discussed about this collision, which is one of the most important basic aspect in the international conventions, the protection of collision. So, here I have presented one picture how the two vessels where they are having the impact or collide with each other is called as collision. Okay. So, collision means it is impact of two moving vessels. Now, what is the meaning of allision? The difference between the collision and allision, where two moving vessels, but one vessel is not yet moved, the another vessel is going to be moved. The impact between a moving vessel and a stationary vessel is called as allision. Let you have to know the basic meaning of the difference between collision and allision. Not only to protection of the collision, including the allision, any action need to be protected, which is the basic aspect of the international conventions as per the maritime law. Now, as such, I told already the two important act, one is Carriage of Goods by Sea Act, another one is Bill of Lading Act. Carriage of Goods by Sea Act here is 1925 and Bill of Lading Act is 1856. But in this, the another important point which may come, what is the meaning of contract of affreightment? Sir, we know about the what is the meaning of contract, what is the meaning of affreightment? Affreightment is nothing but where you are going to enter into the contract to carry the goods by sea. It called as what? Contract of affreightment, where you are going to pay the price, the person who is going to take the goods from one place to another place is called as freight, and also the contract of affreightment is also called as charter party. So, the person who is going to hire the vessel also charter party, the person who is going to take the goods through the sea is also, if he is going to enter with the contract, then it can be called as contract of affreightment, also the name called as charter party. So, who are all the parties which may be present in the contract of affreightment? One is consignor and another one is ship owner. So, these parties which they are going to enter into the contract, where they are going to take the goods from one place to another place, but with the various types of charter parties need to be mentioned in the contract. As per the contract, both the ship owner and charterer, they need to follow the rules and regulations, but any one of the party who do not yet follow the rules and regulations, going beyond the rules and regulations, then only the situation may be in different way, where there is a chance to arrest the vessel or else any person can go to the court. But for that, which act may come into force means Carriage of Goods by Sea Act 1925, which may come into force. Now, what is the meaning of charterer? The charterer means the person who is going to hire the ship is called a charterer. But what, whether the whole ship or part of the ship, even if he is going to hire the vessel, can be called as charterer. But where are the types of charter parties are there? The first one is voyage charter party. As such, I have mentioned only specific ship for the particular cargo for single voyage is called as voyage charter party. Now, what is the meaning for time charter party? Number of voyages or trips but not included loading or unloading cost. There will not be any loading or unloading cost which may not be included, but within that particular period of time they can take n number of trips or voyages. There is no single voyage, there is no specified period of specified cargo or specified voyage like that, which they are not going to mention in the time. The time charter party can go ahead with the number of voyage or trips, but not included loading or unloading cost. And the third one is the charter by bareboat, nothing but the lease of the ship from the ship owner to the charterer, where they are going to take the lease for a certain period of time, can be called as bareboat charter party. But these the various types of charter parties only. As per the charter party, it is an agreement in writing. What type of agreement? Where he is going to take a voyage charter party or time charter party or bareboat charter party? What type of charter party? Let you want to hire the vessel, maybe the whole ship or part of the ship for purpose of carrying of goods. These are the points need to be mentioned in agreement. This agreement only which will be happen between the two parties. One is ship owner and another one is consignor. They combinedly called as contract, or is going to take the goods through the sea called as contract of affreightment. All these points which is most important need to be remembered always regarding with the Carriage of Goods by Sea Act 1925. What is the major classes of charter party? Yes, already which you have discussed the various types of charter party, but for example, I am the charter party, one who want to hire the vessel, means first I need to see whether the ship is in good condition. The ship is in good condition only is called as seaworthiness. And the second one is port of loading, which place they need to load the goods or unload the goods. The third one, which is most important concept, again lay days and demurrage. Demurrage is called as additional cost. For example, what is the difference between lay days and demurrage? Once the ship arrived, they need to enter in the registered arrived ship, the port which may given the time for loading and unloading. Within this particular period of days or the time, they need to load and unload, the work need to be completed, is called as lay days. But if the vessel arrived, the loading or unloading which they have not yet took place within this particular period of time, in such cases they need to pay some additional cost to the port, is called as demurrage. So, regarding this loading and port of loading and lay days and demurrage and payment of freight, already which we have discussed about that freight, where the party is going to take the goods, we need to pay amount, is called as freight. And what is the meaning of ship owner's lien? Lien is called as retain. Okay, lien is called as retain the goods. Who is having the possession? Who is the person who come under liable? Who is having the rights? If anything is happened, whether ship owner is liable or charter is liable. Yes, I agreed. But ship owner is liable for what type of charter party, or else the charterer may be liable for what type of charter party. These are the points which we need to discuss in detail again in the next class about the various types of charter parties, which party may liable, which party may not be liable. And the next one is delivery of the goods, which may be happen in the usual manner. So, these are the most important classes which need to be present in the charter party. Next, when should notice need to be filed in case of damage of goods? Yes, if any goods gets damaged under the Carriage of Goods by Sea Act, they need to send the notice immediately. The notice may be in orally or may be in writing. For that which I have given, if the damage is apparent condition, means they need to give the notice immediately. There will not be any delay in giving the notice. Next one is, if the damage, earlier point, notice need to be given if the damage is apparent. Yes. So, what is there any sufficient provision if there is no apparent? Yes, they are given. If the damage is not apparent, the notice must be given within 3 days after the delivery. So, these two conditions which is most important if you want to file, whether the goods are in apparent condition or not yet in apparent conditions, need to be analyzed, then only you may have the right to file a notice as per which act? Carriage of Goods by Sea Act, which year? 1925. When need to file a suit? Two things as such most important here. One is delivery of the goods in case of damage, where the goods is going to take place from one place to another place. During that period of time, if the goods gets damaged, then you may have right to file a suit. And the second one is the date when the goods should have been delivered. In case, for example, I have already mentioned the goods need to be delivered within specified period of time. within that time period, if the goods not yet delivered, the respective party may have a right to file a suit. The reason is he may suffer some amount of loss. So, two things, one is damage and another one is loss, where any party may have the right to file a suit under which act? Under the Carriage of Goods by Sea Act 1925. Now, previously we have discussed about Carriage of Goods by Sea Act 1925 only for damage or loss. Sir, is there any other provisions? There is no provisions, only you may have the right to file a suit for only for damage or loss. For that, one case law which I have presented here, Hang versus American Steamship Agencies. Now, what is the meaning of Hang versus American? The first party as per the legal term is called as petitioner or plaintiff. The first party is called as petitioner versus American Steamship called as defendant or else respondent. They need to respond. So, which party want to file the case means Hang is one of the person who filed the case against the American Steamship Agencies, but for that the court has given the judgment. What type of judgment which was given by the court? Now, it applies only in the case of which one may be applies as per the Carriage of Goods by Sea Act 1925. This act may be applicable only for loss or damage and not to misdelivery or conversion of goods. The most important point, if you deliver your goods wrongly or conversion maybe took place wrongly, for that this act may not be applicable. So, through this case law they are given the judgment, the Carriage of Goods by Sea Act 1925, which will be applicable only for loss or damage. Now, sir, loss or damage you are saying, is there any other case law? Is there any? Yes, as per section 3 in bracket subsection. Okay, as per section 3 subsection 6 of COGSA. COGSA means Carriage of Goods by Sea Act, year which you all know very well, 1925. There is one case law, Mitsubishi OSK Lines Limited versus CA number, which means the two parties, first party is always called as petitioner, second party is called as respondent. Through this case law only they have given the judgment. This act may be applicable when means only for two reasons, one is damage, another one is loss. Already I have mentioned few important acts. The most important act, two act which you have discussed regarding with the shipping, Carriage of Goods by Sea Act. Another one is Marine Insurance Act 1963. Now, what is marine insurance? Now, first point is, for the first point of marine insurance, it is a contract. Yes, we have agreed it is a contract agreement which includes for two types of insurance. One is hull insurance. The meaning of hull insurance, only insurance of vessels which includes equipments and machinery need to be recorded, is called as hull insurance. But what is the meaning of cargo insurance? Cargo insurance for any mode of transit, it includes ship, consignment through rail and road, where regarding the goods going to be take place from one place to another place. As I told, any mode of transportation, not only the Carriage of Goods by Sea Act 1925 which will be applicable, even the another important act, Multimodal Transportation Act also which will be applicable. For that, what type of insurance which may be most important here means cargo insurance. So, two types of insurance, hull insurance as well as cargo insurance. But when these type of insurance which may have some impact means marine losses. Now, it is a contract between whom? Contract between insurer and the insured to cover the loss or damage of ship, not only ship, cargo, not only cargo, including the property which they are going to, when they have been involved in transferring the goods from one place to another place. So, damage or the loss of ship as well as cargo and property. For this purpose only, which act is most important here? Marine Insurance Act 1963, which is most important. Each and every evidence of a conclusion of the contract, which one is again important here, is various types of marine policies. So, these policies only which you are going to discuss with the help of a few examples. These policies, each and every policy, it is a document which shows that evidence where the parties are entered into the contract, or else it is an evidence of conclusion of the contract. Now, which you are going to discuss with the another few slides about the various types of policies. Yes, the marine policies, as such I told, it is a document, evidence of a conclusion of the contract. There are various types of policies. Voyage policy means where one country to another country, if they are going to take to the particular voyage alone, this policy which will be applicable. But there is any deviations in the route, this policy may not be applicable. Second one is time policy. For example, 11th July 2019, another 6 months time. During this 6 months time, once the goods which has been loaded in the vessel till the completion of particular period of time, 6 months the completion period of time, this time policy which will be applicable. Later this policy may not be applicable. So, they need to complete that voyage within that particular period of time. And third one is valued policy. Valued policy, both the parties mutually agreed for the damage or loss of goods. Both the parties mutually agreed is called as valued policy. Unvalued policy means there not be any such mutually agreed between the parties. There is no such agreed value or agreed sum between the parties other than valued policy only is called as unvalued policy. So, these four types are most important document which can be concluded as an evidence in the contract which may come under Marine Insurance Act 1963. Now, the principles of marine insurance, I have presented only 3 important points. First one is indemnify. Indemnify means to save the person from the loss, called as indemnify. For example, I am the person who have taken the policy, let the insurance company wants to save me from the loss, called as indemnify. Second one is good faith, which is most important between the insured as well as insurer. Third one is proximate cost. The insurance need to be happen, it is the nearest place, called as what? Proximate cost. So, these 3 are the major principles of marine insurance. For in the today's class which we have discussed on the maritime law, one is the contract, Indian Contract Act 1872, and what is the meaning of admiralty jurisdiction, how to arrest the vessel, on what basis they may have the right to arrest the vessel, which court may have the power to arrest the vessel, and later the Carriage of Goods by Sea Act 1925, what are the various types of charter party, what is the meaning of contract of affreightment, and what basis the Bill of Lading Act and Carriage of Goods by Sea Act 1925, both the act which is most important and the contract between the shipowner and the consignor also which is important. And the next which we have discussed about the marine insurance, and the marine insurance there are the various 2 types of major insurance as well as the policies which we have discussed. So, with this I want to conclude about the introduction of maritime law for the today's class. Any doubts, any queries, please text me. I will be available to clarify your doubts. Thanks.